Good morning. My name is Brendan Manning. I'm the Vice President of Education and Environment with the AGC of New York. I want to welcome everybody here today to understanding the impact of ERISA's preemption case. I want to introduce our key speaker for today. Aaron Schlesinger is with Pakar and Abramson. He's going to be covering the program today here with Joe Hogan, our Vice President of Building with the AGC. And with that, I will turn it over to Joe. Thank you.
Thank you, Brendan. When I got word from Aaron and our friends at Pakar Abramson about this decision, I was extremely excited. This law about the Wage Theft Act on private work and the private right of action is certainly something that gives us a great deal of concern. As we have concern about 223 of the labor law. And we did a lot of educational programs on it, dealing with it contractually, dealing with the risk. One of the things that we noted in the risk is there are two, major buckets of risk. One being so-called independent contractors, but this was probably the largest risk from a financial standpoint in our view. We had actually pointed out to the legislature when they were looking to pass this law that this is likely to be an issue, part of our effort to try and stop passage of this law, and I know when we did, the programs and others in Pakar and Abramson's office were, part of that as well. And we knew this was kind of as a potential case, and there was something that was, going down the road a little bit. And so, as I said, very excited about this. And so without anything further, I guess I'll just turn it over to Aaron and then let him talk about the issues and what it means and then some potential issues for the future. So Aaron?
Thank you, Joe, and good morning, everybody. So the first thing we're going to discuss is the summary of the court's holding. The case was entitled Finkel v. Structure Tone. Just want to move something out of my way. It was filed in the United States District Court for the Southern District of New York, and the judge that presided over the case was the Honorable Vernon Broderick. And basically what he held is that ERISA, the Early Retirement Income Security Act, preempts New York's construction industry wage theft statute, Section 198E. It solely applies to circumstances where an ERISA multi-employer benefit fund is seeking payment from a general contractor for the delinquent benefit fund contributions owed by its subcontractor pursuant to a collective bargaining agreement. So again, the case is limited to issues where they're coming after a higher tiered contractor for the subcontractor's failure to make contributions pursuant to their collective bargaining agreement with the particular union. And pursuant to the holding, a benefit fund cannot seek recovery of unpaid benefit fund contributions owed by a subcontractor pursuant to a collective bargaining agreement from its higher tiered contractor, as long as it involves an issue where they're seeking payment pursuant to a collective bargaining agreement. And then the differences between the two statutes is that the construction industry wage theft statute, 198E, renders contractors jointly and severally liable for any lower tiered subcontractor's failure to pay its employees' wages and benefits. The statute came into place, I want to say it was in January of 2022, or somewhere around there. Under the statute, third-party beneficiaries, such as a fund, could sue for unpaid benefits owed to it on behalf of its employees. Very similar to New York's prevailing wage statute and the liability requirements pursuant to the statute on public works jobs, except unlike prevailing wage, it also applies to private jobs. So I guess the legislature was trying to place the same burdens and obligations on general contractors in prevailing wage law projects and public works projects to private works projects, which, as we all know, prior to 2022, that liability did not exist. And I can tell you that New Jersey has also implemented a very similar statute. Under ERISA, it permits and obligates trustees of multi-employer benefit funds to seek recovery of unpaid benefit contributions owed pursuant to a collective bargaining agreement by a CBA signatory contractor. They're obligated as a fiduciary responsibility to seek and collect those unpaid benefits. But ERISA contains a provision stating that it preempts all state laws that relate to employee benefit plans. And the meaning of the provision is that, any state laws that may implicate benefit issues are ineffective if they conflict with ERISA. The goal of preemption is to create a uniform regulatory framework for employee benefit plans, thereby reducing the complexity and the variability of state laws. So if any state law has a similar recovery path as ERISA, ERISA is going to supersede it, and it's going to preempt that state law, and the courts or the parties that are involved are going to be obligated to follow the requirements of ERISA. So interestingly, under ERISA, a party such as a multi-employer benefit fund may only seek delinquent contributions from an individual or entity that has agreed to remit those contributions pursuant to a contract, such as a collective bargaining agreement. So in reality, when the benefit funds are seeking contributions from a signatory employer, it's really like a breach of contract type of case, because there must be some type of obligation, whether it's implied or it's based pursuant to a written agreement, to make those contributions. And if that obligation does not exist, the fund cannot go after, the entity that they're seeking to make collection from. So in this case, the plaintiff was the chairman of the local 3 IBEW benefit funds, and they were seeking contributions in the amount of almost $3 million, allegedly owed pursuant to a collective bargaining agreement by the general contractor's lower tiered subcontractor, again, pursuant to labor law section 198E. Again, as we stated, the labor law statute renders contractors jointly and severally liable for all wages and benefit owed by the lower tiered subcontractor. And I'm sure many of you, and I have several general contractor clients, that get these letters from the fund saying that their lower tiered subcontractor hasn't, paid their contributions pursuant to their collective bargaining agreement. Either tells them they're obligated to withhold money on behalf of the subcontractor, pending the outcome of the legal action undertaken or a settlement, or basically telling them, before this happened under the statute, you're jointly and severally liable, and we're going to come after you. And because the question at issue involved ERISA, it created federal question jurisdiction over the issue. So in this case, the plaintiff, originally trying to be smart, filed a case against the subcontractor only and not the, against the general contractor only and not the subcontractor in the state Supreme Court in New York County, just basically stating that, in the fact pattern, we're an ERISA fund, we're obligated to collect under ERISA. However, we're seeking payment from the general contractor pursuant to section 198E because their subcontractor, did not pay or did not remit the proper benefit fund contributions pursuant to its collective bargaining agreement. So the wording of the complaint, was stated ERISA all over it. So we removed the case to federal court, and the removal was granted. The benefit fund tried to remand it back to state court, but really, in my opinion, it had no basis to do so. And the court's decision was, the court agreed. Well, we argued that ERISA preempted the state law, and under ERISA, there's no cause of action against the general contractor because the general contractor never agreed to pay the benefits of the subcontractor pursuant to its collective bargaining agreement under any collective bargaining agreement or under any other vehicle. And the court agreed and held that Section 198E was in fact preempted by ERISA. The fund had no basis under ERISA to go after the general contractor and dismiss the case. And interestingly, the case was never appealed. And that's probably because the holding was, at least in my opinion, was correct. And they probably realized they weren't going to be successful, in the Second Circuit, which is another federal court. So the outcome is, we believe it's a welcome decision for contractors that perform work through subcontractors. It should be known that the holding applies to all situations where a benefit fund established pursuant to ERISA seeks payment from a contractor under the wage theft law solely based on a subcontractor's delinquent benefit contributions owed pursuant to a collective bargaining agreement. And while this is a case of first impression under the wage theft law, we believe the preemption doctrine could also apply to other statutes in other states holding contractors liable for the unpaid ERISA covered benefits of their lower tier subcontractors. And Joe had asked me prior to providing this presentation, how would this play with regard to New York State prevailing wage law or other state prevailing wage law? And I'm actually looking at that issue for another general contractor client. And I believe there's merit to the argument to state that this would also preempt the prevailing wage state law. The only issue that might impede such a finding is if there's labor payment bonds involved, because that might be considered an agreement to pay for the unpaid contributions. And in those types of situations, you have to look at the wording of the labor bond and the scope of it to determine whether or not, it covers such types of disputes. And then it should be understood that the decision does not address wage payments. It only applies to benefit fund payments or contributions, although maybe argument can be made, but usually funds don't seek payment for wages under collective bargaining agreements. The decision also does not relieve a contractor or subcontractor for its own failure to pay other types of benefits on behalf of its employees as required by New York labor law. For instance, if the general contractor is not a signatory and provides, health benefits through its own private carrier, it may not cover that type of situation. And I always tell clients, prudent contractors should, conduct due diligence background checks on unknown subcontractors, and remain alert to possible instances of subcontractors failing to make wage and or benefit payments. Simply put, do your due diligence when you hire your subcontractors. Make sure, run background checks. And that's what I do for clients. Make sure there's no, outstanding wage or benefit fund cases out there. So that, the subcontractor that you're dealing with, has no issue, no prior issues that could potentially apply to you, moving forward. And given the complexities of the federal preemption and the newness of this wage theft law, contractors should consider seeking legal advice when related issues arise. And that's basically it. And if anybody has any questions, please feel free to ask.
Brendan, just remind folks how to ask a question, the best way to do it. I know there's a Q&A and there's a chat.
Sure.
I suppose we could raise hands, but with a number of people, maybe the Q&A, the chat.
Yeah, if anybody has any questions, you can type them in the Q&A. You should have the Q&A chat. I want to type those in there. Raising your hand, we can. I mean, we have over 60 people on, so it might be a little more difficult. But if you want to do it that way, either way, we can unmute you but chat box is probably the best way to ask the Q&A.
Yeah, and if anybody has any questions, my contact information you can see on this page. Feel free to call me at any time, and I'll be more than happy to address your questions or any issues you may have.
Yeah, and we'll be sharing the video itself and the copy of a PDF copy of the PowerPoint presentation with everyone.
A couple of questions for me, while others, perhaps typing something in. The first that piques my interest, obviously, is the impact on 223 of the labor law, and I don't want to jump ahead of it and tip the hand. But going forward, Aaron, I'm wondering if we and perhaps the AGC of America should be pressing, whether in consensus docs or something else, if there's any need for changes to the labor and material payment bond language, recommended changes to that agreement to ensure that we don't get caught up in that. And so that's just one question that I have. I don't know if you can answer that right now, but it's something to think about or ponder, I guess, from my standpoint.
Yeah, I mean, language definitely, and some of these bonds do have limited language, but you might limit it, and state that this does not cover circumstances, involving a collective bargaining agreement or an ERISA benefit fund. That would certainly do it, putting that exclusion in there, or any other type of exclusion to protect everybody.
The other question is, one of the as Mike Elmendorf likes to say these days, our effort is to try and make real bad legislation halfway livable. This one we didn't get halfway, I don't think. But one thing that the business community was able to do, although I will say the case gets us more than halfway there. But one thing we were able to do was get in a piece about frivolous lawsuits and the ability to get attorney's fees and perhaps other damages for frivolity on the part of a claimant or the lawyer for a claimant. What do you think about the possibility of if a contractor gets a claim in this regard that they're going to have to defend on an ERISA matter to at least hold their place or scare someone off with the specter of getting attorney's fees and other damages back?
So again, if a fund did bring a case against the general contractor, me personally, under the federal rules of civil procedure, there's a Rule 11 where if you believe something, a lawsuit or a motion or any type of filing is frivolous, you can write a letter to opposing counsel, explain why, and basically state, look, if you don't withdraw this within X amount of time, and we have to go forward and I win, I'm warning you that I'm going to be seeking, attorney's fees and other sanctions available. And then it's up to the discretion of the court, which in my practice, I rarely see courts grant sanctions. They're just, they like to give everybody the benefit of the doubt. And the rationale, in the United States, they don't have a prevailing party gets attorney's fees concept, because they feel if they did so, it would chill certain plaintiffs from filing lawsuits for fear that if they lose, they're going to have to pay. But Europe has, the prevailing party wins. But interestingly, in these wage and hour suits, in a way, it's unfair because statutorily, if the plaintiffs win or the benefit fund wins in these contribution cases, they're statutorily entitled to liquidated damages of, I think it's 20%, attorney's fees, and interest. So, you think it would only be fair that if it goes the other way, the employer, should receive same, but that's just not the way the statutes are written at this time. So maybe legislatively you could do something to put that type of language in the law, because the labor law also provides in New York same type of remedies, double damages for unpaid wages, or with benefits, it's also it's liquidated damages and attorney's fees and interest. So like I said, that'd be something, you may want to pursue if you have that ability.
Thank you, Aaron. Brendan, you want to read the questions that we have?
Sure. The first question that came up was, since this wasn't a published appellate decision, what precedential value does the trials court ruling have?
Well, I guess it would be, it would another same level court would not have to agree with it. So it wouldn't have the same effect as if it was the Second Circuit had said it. All the federal district courts would have to abide by it. Same thing with the state court. State court is not bound to what the federal courts say. So they could, and I've seen this happen before in other industries, they could render their own opinion. So, but I believe at least the other federal courts in the state of New York would agree with. I just think logically it makes sense, and legally it was the right decision. I don't think there's really any issues to say why it wouldn't be preempted. But any other district court or district court judge, which is the lowest federal court, could do whatever they want. It wouldn't be binding on them.
Okay. Next question is if a collective bargaining agreement states that the contractor is jointly and severally, excuse me, liable for its subcontractors' contributions to pension funds, will that prevail over the ERISA preemption argument?
Yes, as long as the general contractor is a signatory to the agreement. So a lot of times, general contractors generally don't self-perform, but the unions get them to sign these collective bargaining agreements, and the agreements will say, if you subcontract out work, you agree to subcontract solely to a union signatory. And sometimes there'll be language into that will say you also agree to be jointly and severally liable for the subcontractor's failure to remit contributions. And if that language is in there, then you have the contractual binding language that would give a cause of action under ERISA against the general contractor. Now, if the general contractor didn't sign an agreement and the subcontractor did that says that, then the general contractor would say, I'm not bound to that agreement. I'm not party to it. So, you don't have a case against me.
Okay.
Any other questions?
Any other questions?
Don't have any at this point.
Okay.
Well, we'll give folks one more minute while I say thank you, and Mike might want to say a couple of words. I'll give him the opportunity to do so. But yeah, Aaron, thank you very much for this presentation, and more importantly for this win, because this is you just look at the numbers. The dollar value of the claim that against the general contractor gives you the idea of just how big this issue is, to our GC members throughout the state. And if we can turn around and get a similar victory on the 223 of the labor law, that would be gigantic for the industry, and so I can't thank you enough, as well as to the rest of the team at Picard Aberson, not just for this, but for all the support that they give. Mike?
Yeah, thanks, Joe. Thanks, Aaron and Brendan. As Joe said, definitely an interesting and important decision. Aaron, I just have one question, and I apologize if I missed this at some point along the way, but do we know if the plaintiffs are appealing so that this might rise to the level eventually of an appellate decision that would have a broader force?
Yeah, no, their time period to appeal passed, and maybe they intentionally did that because they don't want the Second Circuit, providing a decision on that issue.
Got it. Well, more to follow. Thank you.
Thank you, everybody. Thank you for the opportunity to speak. I appreciate it.
All right. Thanks all.
Thank you. Have a great day.
Have a good day.